Mr. Siminya.
Good morning to you, Chair, and to the commissioners as well. We have Advocate Ledwaba for cross-examination
Yes.
this morning.
Yes. Advocate Litwaba, you are reminded that you are still under your former oath.
I confirm that.
Thank you.
Good morning, Chair and the Commissioner.
Yes, Mr. Nalane.
Mr. Ledwaba is deposed to a supplementary affidavit which was only obtained yesterday. It has been circulated to everyone. We just want to take him through the supplementary affidavit before he gets cross-examined, because the matters that he deals with are pertinent to some of the matters that the cross-examination will revolve on, Chair, with your permission.
Yes.
Mr. Ledwaba, you would recall that you have previously testified before this commission, correct?
Correct.
And on the 14th of April 2026, you deposed an affidavit.
Correct.
If you look at the bundle before you, from page 13, red 13, and in black it's 1696.
I am there, Chair.
Yes. And if you turn to page 39, 1722, 722. Right there, Mr. Ledwaba?
Correct.
This is your signature and the affidavit which you deposed to on the 14th of April 2026, correct?
I confirm.
You have now deposed to an additional affidavit, a supplementary affidavit, is that correct?
That is correct.
That affidavit appears at the end of the bundle before you. You see that?
After page 385 of the bundle.
Yes, there is a tab called Supplementary Affidavit, Mr. Ledwaba. You call that?
Correct.
The affidavit is not paginated but is numbered at the top of the page. You see that?
I do.
If you go to the last page of the affidavit, page 9 of the affidavit, numbered 9.
Thank you, Mr. Nalane. Now I'm on the same page with you.
Thank you, Chair. There's a signature on page 9. Is that your signature?
That is my signature, correct.
And this affidavit, you confirm it as being affidavit,
I do.
and you confirm it as being correct.
I do.
Now, before we delve into the content of the affidavit, can you tell the Commission why you had to depose to a supplementary affidavit?
I think on the 22nd when I testified, and more particularly during clarification, there was questions regarding the proper reference to section 7 as I had it in my affidavit and in my oral testimony, coupled with the questions relevantly asked by Commissioner Gabriel as to the definition of specified offences in the context of the national director interpreting it one way and the DSO interpreting it probably more another way.
But if you go to your affidavit, paragraph 3, you explain what your previous one affidavit stated.
Correct.
Yeah, just read it into the record. Page 2, paragraph 3 of the supplemental affidavit.
I'm saying in paragraph 3,
Yes.
in my previous one affidavit filed with the Commission, more particularly paragraph 36 thereto, I made mention that the provision of Section 7 of the NPA Act 61 of 2000 provided as follows, open quote, 1A, there is hereby established in the office of the National Director an investigating directorate to be known as the Directorate of Special Operations to investigate and carry out any functions incidental to investigations. A, relating to serious, high-profile or complex corruption, commercial financial crime, and organized crime cases. Roman figure 1, referred to the investigating director by the national director. Those words are repeated in terms of Section 28(1)(b), or Roman figure 2, referred to the investigating director in terms of Section 28(1)(a) or 28(13)(b), relating to additional statutory offenses or categories of statutory offenses, including the contraventions of Roman figure 1, the Prevention and Combating of Corrupt Activities Act 12 of 2004, Roman figure 2, the Prevention of Organized Crime Act 121 of 1998.
So that's how you stated the section to be reading.
Correct.
Now in paragraph 5, you then stated that in your evidence in chief, you repeated that that's how section 7 reads.
Correct.
And then you were asked certain clarificatory questions, correct?
Correct.
And you say, maybe you can read paragraph 4, the second sentence. I indicated that.
I indicated that that my view was based on my reading of the copy of an old NPA Act that I still possessed at my home. This was an error. I have now established the proper position.
So you confirm that section 7, as you have stated in paragraph 3, and as you stated in your affidavit and evidence, is incorrect.
I agree.
And then in paragraph 5, you deal with a document called Circular 1 of 2000. You are explaining why you made the error that you did, correct?
Correct.
Just read that into the record and explain in your own words.
Paragraph 5. What I was recollecting was in fact a DSO Circular 1 of 2000, which did not list TRC cases as cases to be investigated by the DSO. Whilst I have not been able to obtain a copy of Circular 1 of 2000, a reference indicating its existence can be found in the Khampepe report, and the article by a security studies expert, Ms. Jean Redpath. I've attached the relevant sections of the report as Annexure G1 and the Redpath as article as Annexure as G2.
And if you turn to page, there's an annexure to the affidavit is G1. Are you there?
Correct.
When you refer to the Khampepe report, what are you referring to exactly?
I think sometime in 2006, if I remember, a commission of inquiry was established, and that was chaired by none other than Justice Khampepe. And a final report of that commission was then compiled, I think, on the 3rd of February 2006, which was titled in paragraph 11 as the final report, February 2006, Khampepe Commission of Inquiry in the mandate and location of the Directorate of Special Operations.
So that was the subject matter of that commission.
Correct.
The location of the DSO.
Correct.
Now, you also refer to paragraph 48 of that report. Why are you referring to this report in your evidence?
When I started to reflect and decided to look for secular one, I requested assistance of the evidence leaders to approach the NPA to see if they can help us with a copy of this secular, which has not been forthcoming since. And in an effort to get some outside reliance of existence of secular one, I came across the report through talking to some of our ex-colleagues, or some of my ex-colleagues, that we came across the reference of secular one in these two documents, the Khampepe report, where it is even listed that the secular one was even attached to the report, but when you go into the report, it is not there. And the other reference is the monograph by Mrs. Redpath of the ICC. She specifically mentions the existence and the contents of secular one in terms of the mandate, operations and locations. She even identifies the officials at the relevant time in that monograph.
So you're saying when you deposed your affidavit then, you had in mind this DSO secular number 1.
Correct.
To explain it, what was the purpose of the secular number 1?
My understanding is Section 7 of the 2000 Act simply gave a mandate of the DSO, if I can quickly read it.
If you look at your quote from that section 7 as it read then,
Paragraph?
paragraph 8.
Thank you. It spells out the mandate, and more appropriately, under Section 7, 1A, brackets AA, close brackets, identifying which type of offenses falls within that mandate, and it reads as follows: offenses or criminal or unlawful activities committed in an organized fashion. And the second one, which is not really relevant to us, is under BB, such other offenses or categories of offenses as determined by the President in a government gazette. So we go to B, subsection B then defines the word organized fashion, which was the mandate of the DSO.
You are reading at page 4 of your affidavit.
Correct.
Yes.
The last paragraph in paragraph 8. And it says under B, for the purpose of subparagraph A, organized fashions includes the planned, ongoing, continuous or repeated participation, involvement or engagement in at least 2 incidents of criminal or unlawful conduct that has the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are related by the distinguishing characteristics. So that is the first leg of the mandate, organized fashion.
Okay.
Then you move to the second definition of taking it to section 28(1)(a) or 28(1)(b) that says those must then be specified offenses.
But before you deal with that, just explain your understanding of Circular 1 in relation to Section 7 of Act 2000 as you have just read it. How do you correlate the two?
I'm leading it to there.
Okay, thanks.
So I'm saying you take it to 21A, that says all this must then be specified offenses. Only those that can be done by within that context of 28(1)(a) and 28(1)(b). Both refers to specified offenses. Then for specified offenses, you go back to the Act. In section 1 of the definitions, specified offense is defined in section 1, the second last description. It says it means, and I quote, any matter which in the opinion of the head of the investigating directorate falls within the range of matters as contemplated in section 7(1), and any reference to the commission of a specified offense has a corresponding meaning. So to my understanding, it is as vague as it is. And for the DSO to implement this, that's how they decided to break it down. It gives the mandate to the head of that directorate, the head, to define what is specified offense, and that's how Circular 1 came into being, to define exactly in a piecemeal fashion what are those that are regarded to fall within the mandate, and it identified those 4 core criteria of cases.
Okay. If you go to G2, this is an extract from the monograph of the author Jean Redpath.
I confirm.
The numbered page 32 at the bottom, you would see there's a paragraph at the top of the page says, however, agreement between SAPS and DSO. You see that?
I do.
And after that paragraph, then it deals with Circular 1. Let's read that first paragraph and then explain the context of how she explains Circular 1.
I think maybe if we take it on the last sentence of that paragraph, starting with however.
Yes.
She says the ministerial committee never said that is now the MCC.
I think start it from however.
Okay.
Then makes
That's on page 32.
yes.
It says, however, acrimony between the SABS and the DSO arose after the launch of the organization. With the appointment in 2000 of Jackie Selebe, I'm reading it as it is, but it is Mr. Jackie Selebe as SABS National Commissioner, a man who was keen to defend the reputation of the police and who clashed with the National Director. A negotiated mandate became unlikely. The ministerial committee never sat. As a result, the DSO was forced to carry out an internal case review in which it considered whether the matters it had already taken on were appropriate or not. In doing so, the DSO came up with its own operational mandate, more in the nature of internal terms of reference, which outlines the requirements a case must meet before being taken on. This was dubbed Circular 1.
You can explain that?
Next paragraph,
Yes.
in terms of Circular 1, The first criterion is that the matter concerned must fall within the strategic focus areas of the DSO. These have been refined to include drug trafficking, organized violence, in brackets including taxi violence, urban terror, and street gangs, close bracket, precious metals smuggling, human trafficking, vehicle theft and hijacking syndicates, serious and complex financial crime, and organized public corruption. The next paragraph, there are a further 14 general criteria or factors that must be considered, covering such questions as code, is the criminality activity involved complex, and does it comprise at least 5 persons, close quote. There are also financial thresholds that must be met. For example, a corruption matter has a threshold of 500,000 rand, while serious economic offense must involve actual loss of 5 million to meet the threshold requirements.
Then that paragraph, all of these requirements?
All these requirements must be met and consideration canvassed before the head of the DSO will authorize an investigation. I think it had to be the head of the operation, not the head of the DSO, as he could not authorize investigations or declare a matter in terms of Section 28. Prior to such an authorization, no DSO members are designated to a case, and DSO members do not, until designation, enjoy the DSO special powers of investigation, which include somewhat expanded powers of search and seizure.
In simple terms, can you explain what all this means?
In simple terms, for a case to qualify under the intake criteria, it must meet all this. First, the 4 core crime mandate of organized crime, corruption, financial crimes, and the 4th one, which cuts across, is racketeering and poker. So that is the first assignment or the first consideration. Then the second part, we go to the threshold. If it's corruption of 2 million, we give it to the subs. We're starting at 5 million upwards.
But the point is, those criteria were developed in terms of secular one.
Again, aligning it to the definition of Section 1, which gives the head of the DSO to define what will be the core mandate of the DSO.
But
it's
what was
not defined in the Act. It is passed back to the head of the DSO to define what are those.
And what was the rationale for the secular?
To assist the investigators, prosecutors in the regions and even head office how to assess at that level a case to be considered even before they bring it to head office. So when it comes to head office, it must fall strictly within the secular one for consideration.
So if I understand you correctly, not every case, criminal case, would be referred to the DSO.
I confirm. I related to a typical fraud example. Oh, let's take corruption. If it's a corruption and we found that it's for 2 million, it does not meet the threshold. It goes to subs. That's how the high echelon of the crimes was pitched.
And then if we go back to your affidavit, supplemental affidavit, you go to paragraph 3, paragraph 7, you say, the evidence leaders and I agree that I would then have to address these issues by filing a supplemental affidavit in these proceedings, which are now due, correct?
Correct. I think we need to say immediately after, in paragraph 6, we say immediately after my testimony, we converged with the evidence leaders and re-looked at taking the questions raised by the Commissioner Gabriela SC. And looking at the Act, it was obvious that I was mistaken there. Section 7 was not as I indicated. And that's when we said, I must go and look at it. And that's how paragraph 7 comes into the picture.
And you now deal with the correct citation of rendition of section 7 in paragraph 8 of your affidavit.
After our agreement, I then decided to follow it up, and when I came across the act, I established that the correct section 7 read as we have it under paragraph 7 as it is in that Act 61 of 2000. And it reads as follows, 1A, Roman figure 1, investigate, now that is the DSO, has to investigate and carry out any functions incidental to investigation, gather, keep and analyze information, and where appropriate, institute criminal proceedings and carry out any necessary functions incidental to instituting criminal proceedings relating to, and that is now the mandate again, Roman figure, capital A, brackets AA, close bracket,
I think it's fine. You've read that into the
offenses or any criminal or unlawful activities committed in an organized fashion.
But if you may pause there, the operative word there in AA is organized fashion.
Correct.
Yes, may proceed.
And the BB is really not relevant, but it's here, I'll read it, such relevant for these purposes, but it says such other offenses or categories of offenses as determined by the President by proclamation in the Gazette.
And then B defines what organized fashion means, correct?
Correct.
Now if you go to 9, what do you say in 9?
I will read it. I still remember that the DSO strongly relied in interpreting its mandate as being strictly for Roman figure 1, serious and complex financial and commercial cases, 2, serious and commercial corruption cases, 3, serious and complex organized crime cases, and 4, serious and complex cases relating to racketeering and poker, and approved investigations within these 4 parameters.
Okay, thanks. In paragraph 10, you've already testified that after your testimony, a colleague of yours alerted you that you may have been confusing matters. Correct?
I confirm.
Yes.
And pointed out that I was probably referring to not the correct section 7 as I had cited, but more relevantly to circular 1 of 2000.
And then in paragraph 11, you've already testified about the extract which we have from the Khampepe Commission of Inquiry
Correct.
into the mandated location of the Director of Special Operations. Correct? As well as the monograph from the author Redpath.
Correct.
Yes.
And we say in that paragraph 11 that the Khampepe, full copies of the Khampepe report and the monograph of Redpath are too voluminous to attach here. But I know, I've been told that the evidence leaders have made it easily accessible online.
Yes. And then just to make the point about the Khampepe report, just go back to what the circular, as you understood it, and as was referred to in that report, would say and do. If you go to G1, Annexure G1,
I'm there.
paragraph 49. Yeah, read that aloud and explain it.
Sorry, say that again.
Paragraph 49.
Must I read it
Just
out?
read it and explain it. Yes.
Paragraph 49, we took out and made a copy of this from the report, the Khampepe report itself, and it read as follows. The circular, that is now circular 1, divides the work of the DSO into various areas of focus. It establishes 4 operational management desks. The circular also deals with the criteria for the selection and initiation of investigation and the procedural requirements relating to these processes, including the reporting responsibilities of the regional heads. It also deals with the referral of monitoring and interception application and request in terms of section 252 capital A of the Criminal Procedure Act, that is dealing with the entrapments.
Right, we may now go back to your supplementary affidavit. So in other words, you are saying the report, as you have read it, deals with the secular one, which you had in mind when you were doing your first affidavit of April.
Correct.
Now go back to paragraph 13 on page 5 of your supplementary affidavit.
1-3.
1-3, yes.
I continue to read it. I now confirm that my continued reference to the DSO mandate then being to investigate specified offenses of 1, serious and complex financial and commercial cases, 2, serious and complex corruption cases, 3, serious and complex organized crime cases, and 4, serious and complex cases of racketeering and involving poker was in relation to how the DSO interpreted the legislative mandate within Secular 1 and used this criteria to assess and approve investigations.
And then you also deal with further elaborate on that on paragraph 14.
Paragraph 14, from my understanding as I remember, the DSO developed its own criteria for intake of cases and refined its operational implementation of the mandate by introducing, it says, a so-called Secular 1, and this is now the title as it is in the Secular. Secular 1, open bracket, the Office of the Head of the Operation DSO Secular 1, which became operational on 8 November 2001 and approved by Advocate L.F. McCarthy. So if I can take the commission back to the definition of, in section 1 of specified offense, one will see that after that there is an insertion that says the definition of specified offense was inserted by section 2D of Act 261 of 2000 with effect from 12 January 2001. So between then and until November, the DSO was then developing exactly how to define specified offense, and only in November the work was finalized and the policy was then approved.
So when you talk about to refine its operational implementation in paragraph 14, what exactly do you mean?
My understanding is that the definition as it is too wide. Anything could have probably fell under specified offense if we really, if I can take it to the new act and that replaced the DSO, I see it even refers to any offense involving dishonesty. So I'm saying if one follows the new act, if I'm stopped by a traffic cop and I'm giving a dishonest name, so the DSO would have then investigated that. So our understanding was to high pitch the intake criteria only to a high level type of cases, and that's how the 4 core intake case criteria came up.
And you elaborate that on paragraph 15 of your affidavit, on page 6.
Paragraph?
15, 1-5.
Correct. Yes. It says, I was made to believe that the Secular 1 came into being as an attempt by the DSO to interpret the legislative mandate and dealt with the identification of types of cases falling within its mandate and criteria for the selection and initiation of investigations.
Okay. We have dealt with the extract from the monograph of Ms. Redpath, which we have dealt with in paragraph 16, so we don't need to deal with that unless you...
No, I confirm.
Yeah, thank you.
She confirms the existence of Secular 1. She confirms the 4 operational management decks that are linked to these 4 intake criteria of the cases that I testified about on the 22nd of April, and which are now in Secular 1.
And then what do you say in paragraph 17?
I'm saying it is now I now confirm that the legislative mandate of the DSO as provided for in Section 7 in 2000, I'm saying then, was to investigate organized crime.
And then, although you have dealt with, you can just refer to it briefly. Paragraph 18,
We take it to
organized fashion.
to 7.1b, where the word organized fashion, which is established in A, is now defined. And I've already read that relevant section from the Act.
Then at 19, we still deal with the definition of specified offense, which you have dealt with.
Correct.
But maybe just emphasize, we say, is intent defined as any matter which, in the opinion of the head of the investigating directorate, falls in the range of matters contained in Section 7, 1A, and any information in terms of Section 7, 1A, BB, or 1A of the Act. We have dealt with that.
I have done so. But I think just to highlight, to say, the legislator did not, for whatever reason, decided not to define specified offenses and threw it back to the head of the investigating directorate, who was then Mr. Son. But I see Mr. McCarthy signed and approved that circular one. So that's how the specified offenses were then had to be defined specifically in line with the mandate in Section 7, pitched at organized crime, organized fashion.
But again, in order to refine the mandate of the DSO.
Correct.
Then in paragraph 20, you deal with an extract from the Khampepe report.
Correct. We referred to, if I can first read it, the Khampepe report mentions in paragraph 11.19 of the report that the foundation of the human rights, FHR, expressed the view that the provisions of the Act, which dealt with the mandate of the DSO, provided very little direction to the organization. And I say that I agree with the expressed view. And I noted from the report, Chair, that Mr. Valley is the one who made this submission on behalf of the FHR then in that Khampepe proceedings.
Thank you.
So basically we're saying the Act does not define what is specified offenses, and it gave it, threw it back to the head of the organization, and that's how Circular 1 came into being.
And then 21.
The Khampepe report highlights that the implementation of the legal mandate then became an issue when it came to operationalization of projects that were to be regarded to fall within the mandate. 22, I say I believe, which is essentially what Ms. Redpath also says, that the failure of the Ministerial Coordinating Committee in addressing the issue of the DSO mandate resulted, amongst others, in the DSO being creative and brought to life Circular 1 of 2001, which was aimed at defining and streamlining the mandate of the DSO.
Thank you. And then 23.
The circular provided in the main that the investigating director, which is the head of operations, may investigate any matter which in his opinion involves a specified offense, one which is related to organized crime or any other categories determined by the president.
At paragraph 24, you just simply emphasize that for a matter to come to the DSO, it had to fall within the 4 emphasis areas.
The first point is always specified offense. What is that? Then to break it down, we came up with those 4. And in paragraph 24, we say in deciding whether to declare an investigation in terms of Circular 1 regarding the DSO mandate, the first criterion was that the matter concern must fall within the strategic focus area of the DSO, which was then defined to mean 1, serious and complex financial and commercial crimes, 2, serious and complex corruption crimes, 3, serious and complex organized crimes, and poker. This was the cornerstone of Circular 1 insofar as the mandate of the DSO was applied.
And then in 25, you deal with 14, you mentioned that there were 14 general criteria or factors to be taken into account.
Correct. And I think this also assisted in dealing with the tension between subs, that the DSO not necessarily cherry picking cases, but has a threshold. And paragraph 21 says there were further 14 general criteria or factors that had to be taken into account, namely the scope of offenses to be investigated, organized fashion, syndicate, impact, international or transnational, at least 5 or more people involved. That's 1. 2, there was in addition threshold amounts to be considered on each investigation in terms of those, the criterion 1, 500,000 being the minimum set for corruption cases, minimum actual loss of 5 million rand for financial and commercial crimes, and 3, value of 1 million rand for organized crime cases, and 5 million for drug syndicates. So this was to put a bar. To
So
say
that not every case,
not every case of corruption will come to subs. So the police the subs will not say, we're taking every run-of-the-mill cases, even if it's a corruption of 100,000 of 2 million. So that's why we said for corruption, the minimum was 5 million, 500,000, and for financial crimes, 5 million. Drug syndicates, 5 million.
then you conclude at paragraph 26. What do you say in paragraph 26?
I confirm that the correct legislative mandate of the DSO was to investigate organized crime as intended in section 7. My reference and reliance to the language that was used in Circular 1 was an error on my part.
Thank you. Chair, those are the questions for Mr. Ledwaba.
Mr. Ledwaba, can I take you back to paragraph 3 of your supplementary affidavit? Where you quoted the provisions as you understood it of section 7 of the NPA Act. Are you with me?
I am a commissioner.
What were you looking at when you drafted this?
To the best of my recollection, was an old NPA Act, which unfortunately I've been unable to get a copy of. I don't know whether that one was probably in the proclamation before it was enacted, or I just can't remember whether it is the wording of the Circular 1 I had in one of my notes. I still had some few documents from this DSO then.
But you were quite clear
I was quite clear.
that you were relying on your old version of the NPA Act.
I confirm that.
And now you can't find it.
No.
Thank you.
And even if one reads the current section 7, then it does not read close to this.
Thank you.
Thank you. Ms. Moroka, following upon the supplementation of the evidence by Mr. Duaba, any clarificatory questions?
None, Chair. Thank you.
Thank you. Ms. Ntambeleni,
Thank you, Chair. No questions.
thank you. I think this will be an appropriate time to adjourn for tea, Mr. Vani, before you conduct your cross-examination.
As the Commission pleases.
Yes, we'll adjourn for tea until 11:15.
Switch on your one microphone.
Chair, before we start, we're told there's a Mr. Lukele for the NPA team who's on MS Teams. Who's online.
Okay.
Yes.
Yes. Mr. Lukele? Mr. Lukele? Can you hear us, Mr. Lukele? We don't have Mr. Lukele.
That should be in order.
Yeah. Mr. Vani?
As the chairperson pleases, with the leave of the Commission, I'll commence my cross-examination. Firstly, Mr. Ledwaba, thank you for taking the time to come back and be with us today and assist the Commission. It is appreciated.
Thank you, Councillor.
To assist you, we also set out virtually all of our questions in the application to cross, so there are not going to be any surprises today.
Yes, I was surprised with that affidavit where the questions are set out and I've went through them.
Thank you. So we will try not to keep you for too long, and just to assist you to navigate this morning's session, we're going to kick off on page 2 of that application. There's a heading titled the Special National Projects Unit dealing with the TRC cases. It's at paragraph 7.
If I may be assisted with the page number in the bundle.
It's 2. Red 2.
I'm there. Thank you, I'm there.
Good. So at paragraphs 50 to 51 of your first statement, you made reference to the fact that the Special National Projects Unit, the SNPU, within the DSO, have been dealing with 14 cases, and you set them out, and we've also reproduced them on page 2. And actually, going through those cases, I should indicate that I'm representing families in at least 4 of them. That's COSAS 4, CREDOC 4, PEPCO 3, and TMO. We will return to these cases at a later stage, but I will just indicate that, just to bring you into the latest position in respect of at least those cases. In COSAS 4, prosecution was opened in 2021. In CREDOC 4, the reopened inquest is proceeding this year. In PEPCO 3, an inquest will take place in October of this year. And in TMO, there was a reopened inquest in 2017. I'm not representing the family of Steve Beaker, but I am aware that there will also be a reopened inquest in that matter, either later this year or next year. But turning back to your listing of these cases as matters that the SNPU was seized with, can I ask, under what legal authority did the SNPU, which was part of the DSO at that time, under what legal authority did the DSO take on those cases?
Simple answer is none.
Then how did those cases get to the DSO?
We take it maybe 2 steps back. all the TRC cases were initially at the SABS and DPP offices after the TRC. Mr. Nguka, as the national director, decided to bring them in his office, in the national office, but in his office. And that's where the SNPU was developed and started operating in his office with the whole range of 400 or 41, I can't even remember, but that's how it landed in the DSO. Mid-2002, if I'm correct, or early 2003, Mr. Nguka with management decided to move the SNPU out of his office and just dump it in the DSO with the purpose of the SNPU dealing to DSO-related national projects. But they brought along Mr. McAdam, Mr. Lisk, and few others, together with what they were doing there. They continued working with them, even though they were now in the DSO, but those projects or those investigations were never declared in terms of either 28-1A then or 28-1B. So it was just a carry case that they brought along and they continued working on them. That's why I said no legal authority.
But nonetheless, those cases were regarded as serious cases, serious enough for the DSO to be seized with.
When you say they were regarded, you mean by whom?
Well, presumably Advocate Nguka and the DSO.
I think we're missing each other. He just removed the unit as is, continued working on them, but now located within the DSO with the main aim of now dealing with DSO national projects together with what you are bringing along. So there were
Yes.
never DSO cases.
But to get onto the same page, not any old case would be just handed over to the DSO. The point I'm putting to you is that these were serious enough cases dealing with organized political crime that warranted the attention of the DSO.
Not to my understanding. I have to differ with you.
We'll have to agree to disagree on that point. Now, you mentioned in your statement that that's in paragraph 50, an audit of all the matters that have been dealt with by the SNPU was carried out. When approximately was that audit?
This was around 2003. I cannot try to even estimate. I can't remember. But
you
the
said
one identifying the 14 cases would have been approximately when we decided to comply with the NPA policy of now regarding TRC cases as priority crimes within the PCLU, and for us to compile a list of what are we now transferring to them for them to carry on. Should be around that period.
And around that time, aside from the 14 cases, was the SNPU dealing with any other TRC cases?
Yeah, if you remember in my testimony, Chair and Commissioners, I stated even in the memo of directed to Mr. Lisk dated 15 July, that after these 14 are now transferred to PCLU, only 2 cases will be remaining in the SNPU just for finalization on the request or direction of Mr. Nguka, being the blackheads. If you go to page red 41, paginated red 41, the annexure of the memo identifies in Roman figure 1 the Black Cats and the Winnie Mandela cases. Those are the only two that remained not as DSO projects or DSO authorized investigations, but the carry on that they brought, and when they leave, they must retain those two for completion by July 2003.
Right, we'll return to that. But the reason I ask whether there are any other TRC cases on the books, this is because of what we set out in paragraph 9 of the application, paginated red number 3. And let me just put to you these assertions, because it does seem to us that there might have been more than just 14 cases on the books of the SNPU. So, for example, if we look at 9.2, TRC provided a list of approximately 226 TRC cases to the Human Rights Investigation Unit, the HRIU. And then we know that, and you've also indicated this, that Advocate Nguka stated that after the HRIU assessed the TRC cases between 1999 and 2000, he decided to transfer all the TRC cases in possession of the HRIU to the SNPU. And then lastly, we can make reference to the statement of the former head of the SNPU, Advocate Chris McAdam, who indicated in his own statement that by 10 February 2003, the SNPU had identified 41 TRC cases for investigation and possible prosecution. So it does seem as if the SNPU probably had many more TRC cases on its books at that time. Would you agree?
From my understanding, remember I said the SNPU started in, if you look at what Mr. Nguka is saying, he brought along, you said around 200, which were then in his office. That's where the SNPU started operating, and I suppose when Mr. McAdam refers to the 41 being with SNPU then, that was at the time, it was still located in the NDPP, Mr. Nguka's office. When they came to the DSO, they officially then put on our records only the 16, let's say the 16 cases. That's why on the project management office, their audit only picked and identified the 16 and not 41. But Mr. McAdam has been carrying the SNPU, 1 in the NDPP, 2 in the DSO, and 3 when he moved to the PCLU. So he will have a complete list of all those that he regarded as ready for investigation and possible prosecution. But these were never DSO authorized investigations.
Let's turn to what you refer to as the turf war between SAPS and the DSO. And you indicate, this is actually in your evidence in chief, your oral evidence, that everything started after the final TRC report was handed to Parliament in March 2003, and following President Mbeki's speech to Parliament on 15 April 2003. Am I right in saying that the turf war you are referring to is the same conflict between SAPS and the DSO that Jean Redpath refers to in her article, the one that you attached to your supplementary affidavit, where she refers to SAPS being unhappy with DSO allegedly cherry-picking the best cases and the like?
Correct, and also as dealt with in the Khampepe report. There's a topic dealing with that tension between the two institutions.
So this turf war, correct me if I'm wrong, wasn't about the two organizations trying to nab TRC cases.
No, not in TRC, not at all.
Indeed, as we know, there was an attempt to, offload the TRC cases.
Oh, pass the buck between.
Both, pass the buck, exactly.
Yeah. But the tension itself, I'll probably agree with the Khampepe that it started more on a personal level of the two heads of those organizations there and filtered to down, where most of the investigators from DSO come from SABS, and some brought their informers and decided to continue with the investigation that they were carrying, but those were not high enough to fall within the mandate. And that's where the SABS started accusing DSO to cherry pick without having regard to what was said in Circular 1. It was not more of a cherry picking, but streamlined intake that was agreed upon and used. The only mistake maybe is that Circular 1 should have been properly being addressed between the two, not done by the DSO alone.
So this turf war, did it impact the work on the TRC cases, and if so, how did it impact them?
To my best understanding, it had no impact directly, because it was more on operation of the type of investigation the DSO could authorize and did authorize, which did not include TRC cases. But then it became relevant when PCLU took over the mandate of TRC matters, and they went to SABS to say help, and we know what happened. SABS pushed it back to say, take it back to the DSO. Mr. President says NPA, and we believe NPA is the DSO. So that's how it affected.
Okay, so in some respects, what happened there was something of an extension, perhaps, of that tension between the two organizations.
Insofar as TRC cases, we never had tensions with SABS. We firmly held the view that now they are within PCLU, they will deal them with SABS.
Yes.
Now,
Okay,
when
we'll get to that claim shortly.
So insofar as the tension between, it was not more on between the two units. It didn't touch the TRC cases.
So you just put up the turf war for contextual purposes.
Correct.
Right, let's turn to the interpretation that you've offered of sections 28(1)(a) and (b) of the NPA Act, and you've now put up a supplementary affidavit in which you have attempted to explain what took place. I'll try not to repeat too much of what you've alluded to this morning. But it's now apparent that the quote that you offered of Section 7 of the NPA Act, or at least the old Act, is incorrect.
I agree.
But as far as we can tell, we've also looked for it. You haven't been able to produce that old Act.
I confirm.
We also can't find it. You have made reference to the fact that you really meant to refer to Circular 1, and although you've referred to references in the Red Path article and the Khampepe report, you haven't been able to produce Circular 1.
Well, in the affidavit, we show all the attempts I think I've requested the evidence leaders, I think twice, and a follow-up to the NPA. I don't think Council is expecting that after 20-something years I'll still have a copy of the Circular 1. But neither the NPA seems to be having a copy of Circular 1, and that's why we sought to get supporting information that Circular 1 was in fact existing, and we found two reliable sources in the sense of the monograph of Ms. Redpath and the Honorable Judge Khampepe in her report of 2007.
Yes, no, we didn't expect you to have your own copy after all these years, and thank you for confirming the attempts that you've set out. Now, you have made reference to the NPA Amendment Act of 61 of 2000, which sets out Section 7, and you've gone through it. But just for completeness sake, and we've also reproduced it at paragraph 13 on red paginated number 5.
I'm in agreement.
Yeah, so it essentially talks about offences of any criminal or unlawful activities committed in an organised fashion. We won't dwell on BB because it doesn't really apply to us in this instance. And then 7.1b sets out what organised fashion means, including a planned, ongoing, continuous, repeated participation involving at least two incidents. So we want to put it to you that the DSO mandate is what is set out in Section 7.1, namely to investigate and prosecute offences of any criminal or unlawful activities committed in an organised fashion. It doesn't speak of serious, high-profile or complex corruption, commercial or financial crime and organised crime cases. This is simply what is set out in Circular 1.
I agree.
So as I understand your central proposition that you set out in your supplementary affidavit, you're essentially saying that those four categories, although you accept that those are not in the NPA Act, they're based on the internal Circular 1. Would you agree with me that that circular guides the DSO in terms of priorities and case selection, but it could not amend the statutory mandate or remove jurisdiction conferred by Section 7 and 28 of the NPA Act?
Interpretation is a wide concept. You have to go to Section 1. Unfortunately, according to me, that defines, as we said, Section 1 defines what is specified offense in the context of the DSO. It is not being given anyway. So the DSO, it says specified offense means any matter which in the opinion of the head of the DSO falls within the range of matters that they deem fit. And for that purpose, DSO management or DSO head came up with the 4 intake. Whether that one can accuse them of widening or narrowing the mandate, it's subject to debate.
But you do agree that as a matter of law, an internal DSO circular cannot supersede or amend the NPA Act?
Literally, I agree. But again, if you follow what definition of specified offense...
How can there be a but?
Sorry, Commissioner?
It's an internal circular. It can't trump national legislation. There is no but about it.
That is why I said literally I agree. But operationally, one has to give meaning to the definition in the Act of specified offense, which comes back to Section 7. What is specified offense? Section 7, the definition in Section 1 makes it plainly the table of the head of the DSO to define those specified offenses. And that's why I'm saying literally I agree. It cannot trump the Act.
Mr. Vani?
Thank you, Commissioner. So would you also agree that the fact that the internal circular doesn't specifically refer to TRC cases doesn't mean by itself that the TRC cases are excluded?
That if that what this council's view is, I'll accept it. But that is not my view or the DSO then.
Well, perhaps you need to tell us what your view was.
Our view was that the Scorpions or the DSO was created to deal with organized crime. And that is the intention of the legislator.
Let's turn to organized crime. And as we've just looked at Section 7 and that definition, Section 7 covers offences or unlawful activities committed in an organized fashion. And organized fashion was, as mentioned, defined by reference to planned, ongoing, continuous or repeated conduct involving at least two incidents with common features. So the question is, surely the TRC cases squarely fits into the definition of serious crimes committed in an organized fashion, does it not?
Well, it depends on who is saying it. My interpretation, if we were to follow the exact wording, DSO can as well investigate everything. As it reads here, two people ongoing, we don't have to look, what is it? It falls within this, we take it. So then TRC cases can, theft of syndicate of Woolworths can fall within the DSO, and I don't think that was how the DSO was intended.
Let's not be glib about this, because we're referring specifically to the TRC cases. And we know that these were planned, orchestrated kidnappings, killings, disappearances, often organized by a central chain of command, often involving the same perpetrators. And I hardly need to say that there were more than two of these offences. So just as a matter of plain reading, the TRC cases fall squarely within the definition of organized fashion of Section 7.
That your position will obviously follow that way. Mine will be different. And to justify, the national director, even then, saw it fit that they do not fall this and pitch them differently as priority crimes and created a proclamation to accommodate them. If it was his view then that they fell within this, he would not have moved them out of the DSO and classified them as priority crimes and removed them out of the DSO, created a unit to deal with that. So it's not only my position, but the whole NPA.
Well, we certainly...
Whether we were correct or not, or whether Mr. Vani is correct or not, that's another debate. But that's how we operated.
Well, in due course, we're going to be disputing the claim that the National Director moved the cases out of the DSO. There's no evidence. There's not a whisper of evidence suggesting that. But we'll come to that. But even in Circular 1, there is a reference to organized crime. And even under Circular 1, we suggest to you, read with Section 7, that these TRC cases involving murders, kidnappings, disappearances, and the like, clearly fit the definition and the way they were executed as being carried out in an organized fashion.
That's the beauty of the law. I will interpret it differently, and the council will interpret differently. And that's how it worked in 2002 and 2003. If anybody is to say we were wrong, that's a question the commission can ask, or a judge in a dispute between the two can then decide. But that's how we interpreted it, and that's how we worked.
Now, I want to deal with your interpretation of section 28(1)(b). I want to refer you to something you said in your evidence in chief. It's at page 352, paginated red page of the bundle.
Page number?
352. You found it?
Correct, I am there.
So I just want to quote to you one line for your comment. However, the national director is given superpowers in terms of that subsection, that's 28(1)(b), to go beyond the mandate of the DSO. Are you still persisting with that view?
I think to contextualize what I meant is both 21A deals with specified offenses, which has to be defined. And we then decided to say it's A, B, C, D, the four. 28(1)(b) refers to the same specified offense. So there should be a difference. And that's where I meant that the national director is given superpowers, but in practice it essentially means the national director is given power that, according to our understanding, or my understanding at least, if a matter is brought to the DSO, it's a corruption of 100 rand or 100,000. The investigator director, who was myself then, feels that it does not meet the other 14 criterion, especially the threshold or the importance of the matter. I decline to authorize it. The people involved feel aggrieved and they take it to the national director to review. So even though it does not fall within, according to a secular one and our understanding, he has the powers to authorize it, even though he would agree that it doesn't fall within, strictly within, but on his consideration, he decides to, the word shall. Once he says the DSO must, then we do it. We don't consider anymore whether it is within the mandate. As long as it comes from him, we don't question. That's how, when I said superpowers.
So, do I understand you correctly to say that you're still persisting with the claim that because the national director has these superpowers, he may go beyond the mandate of the DSO?
I think maybe the word superpowers is problematic. Let's just say 28(1)(b) gives him a power to declare certain matters at his own discretion back to the DSO. And it doesn't define for him what is specified offense. Whether he interprets it like us in terms of the act, I cannot answer for him. But as long as he feels satisfied that whatever is on his table fall within that specified offense in 21(b), I'm happy to comply with his instruction. So I cannot answer for him as to what he regarded as specified offenses.
So are you suggesting that the section allowed him complete carte blanche? He could pick any offense under the sun and say that, this now must be investigated?
If we want to be simplistic, yes. He can take a theft of a Woolworths by a prosecutor to be investigated by the DSO.
Well, I must put it to you, Mr. Ledwaba, that as a proposition of law, that is just manifestly wrong and cannot be.
That's why we're saying one had to pitch a standard to say we stop here. The rest goes to subs, above comes to DSO. It would not have worked out if one were to follow the literal meaning of the definition in 7.1b.
Now, you've pointed out that both 28.1a and b refer to specified offences. Are you suggesting that 28.1b had a separate or wider definition of specified offences, or gave the National Director an approach to go beyond what was anticipated in Section 7?
I would not say I really ever bothered myself in trying to define the specified offences under 2.1b, otherwise it would have made me to be at odds with my boss, Mr. Nunga. That was his definition. I'm more on 28.1a, which gives me the powers.
All right, well, let me just put the following to you. Specified offences in those two subsections had the same statutory meaning. Section 1b did not contain a separate wider definition. Nothing in subsection 28.1b permitted the NDPP to turn an offence outside Section 7 into a specified offence merely by referring to it. The difference was principally who initiated the investigation and whether the investigation was discretionary or mandatory. Your comment?
I differ a little in that the definition of specified offences in the Act talks about the head of the investigating directorate who must decide what are the offences, not the national director. So if one were to do a literal interpretation, specified offences as defined in the Act missed 28.1b, because if the national director is doing specified offences that are to be decided by the investigating head of the DSO, it creates an imbalance. Whether he felt that the specified offence under 21b are what is covered under specified offences in Section 1, I cannot answer for him, but that's my understanding. The problem is the wording of the definition of specified offences in Section 1. Limits it only to the head of the investigating directorate, who is below Mr. Nuka. So I don't think he can bind the head of the organization as to how he defines specified offences. Obviously, he must be bound by the Act, but the interpretation is unfortunately a little complicated when you read how the legislation is formulated.
Well, we want to suggest that your interpretation has no textual basis in the Act. And so your suggestion, and I want to refer you now to page 382. This is part of the transcript of your evidence in chief. And I'm going to quote to you the example that you put up at line 18. I always argue that even a theft of Pick and Pay, he could have just said, use 28.1b, it is a specified offence, go and do it. I want to put it to you that your example that the NDPP could turn an ordinary Pick and Pay theft into a specified offence merely by referring to it is manifestly incorrect.
Again, I differ. If one looks at the definition in 7b, says if there are two more people, syndicate. If it's a syndicate of two people, dealing with Pick and Pay, targeting Pick and Pay, it can still fall within this, as it is. So it's a matter of interpretation. We are highlighted, as they say, according to them, TRC cases are continuing, organized. Pick and Pay syndicates are continuing syndicates, organized. What is the difference?
Yes, although I dare say you weren't referring to a syndicate in that line, but be that as it may, just to wrap up this section, I want to put it to you that if a matter genuinely fell outside the definition of specified offence, Section 28(1)(b) could not bring it inside. Conversely, if it was a specified offence for paragraph B, it was capable of being investigated under paragraph A.
We're talking across each other. Again, it goes to the definition. I will define B differently from you. And who is correct is subject to High Court, SCA, Concord. I'm citing an example of a syndicate of 5 people targeting Pick and Pay for theft. 40 rand, 50 rand every day. Why there's no difference. It is a continuous targeting syndicate of people. Can it really be dealt with by the DSO? No. It doesn't mean we were correct or we were wrong. It depends on who is listening or who's talking.
Now, this issue was raised with you by Commissioner Gabriel in your evidence in chief, and she put it to you that if the NDPP could form the view that the TRC matters were specified offences for purposes of 28(1)(b), it was not clear why you did not form the same view for purposes of Section 28(1)(a). And in your evidence in chief, you said, well, this is how the DSO interpreted its mandate at the time. So my question to you is, do you accept that Section 28(1)(b) did not dispense with the requirement that the matter referred by the NDPP must relate to a specified offence?
We have already dealt with that. How he defines specified offence, I don't know. How we define specified offence is within the Act. So even if we operate on the premises that he was wrong, therefore we should have followed the wrong procedure, I do not agree. Or he was right, we were wrong, that's how we worked.
I want to put it to you, Mr. Ledwaba, that your explanation on these sections are not only illogical, but putting them up to turn down the investigation of the TRC cases at that time frustrated the investigations of the TRC cases.
I will dispute the illogical insofar as I am relying strictly on the definition in the Act of specified offences. Mr. Vani has not given us how he interprets the definition of specified offences, which can lead him to say, well, TRC cases should ideally be regarded as specified offence as defined in this Section 1. And that we caused the derailment, that is definitely incorrect, because Mr. Nilka's office by Mr. McAdam, and he left with them to PCLU. We gave all the support in terms of researchers, storeroom and everything, and even implored Mr. Lisk and his team to assist the subs to make sure that the handover is smooth and they can continue. How that can be regarded as derailment beats me.
Mr. Vani, can I interrupt you?
Please do.
Do you accept that if your interpretation of the law was incorrect, that this impeded the investigation of the TRC cases?
I don't see how a commissioner, in the sense that in May, not the DSO, Mr. Ncuka took a decision, obviously after consulting and with the NPA, to move them out of the DSO to somewhere else.
I'm referring specifically to when you had the disagreement with the prosecutors.
But that was after May. So already the decision has been taken by NPA management that they are no longer DSO cases. They are somewhere outside of the DSO. They go to SABS, SABS also gives them a dead hole, then they decide to come back to the DSO. After Mr. Ncuka taken them out of the DSO, it defeats the purpose of taking them out of the DSO, coming through a back door again to the DSO. So the fault should not be attributed to the DSO, but the steps that were taken to move them out of the DSO to somewhere else for them to be attended as priority crimes.
Okay, thank you.
I don't want to repeat ground that we've already covered, but you've asked, where's my view on specified cases. I just want to remind you that we've had quite an extensive exchange on Section 7 and the reference to these crimes being committed in an organized fashion, as well as the reference to organized crime in Circular 1. And I put it to you that quite plainly the TRC cases would have fallen within both Section 7 as per crimes committed in an organized fashion and organized crime as mentioned in Circular 1.
That is Council's view. I hold a different view. But what I want to emphasize, Commissioners, is that we must remember that the DSO had these cases for a span of 3-4 months, beginning of 2003 until May. May they are gone. Can we say in those four months anything could have been done that the DSO failed to prosecute or investigating them? After May, they were officially transferred out of the DSO. So we must always have that in mind.
Now let's deal head on with this interesting claim that you make that Advocate Nguka decided to remove the TRC cases from the DSO to the PCLU. Am I right in saying that you rely on the presidential proclamation, which is in the bundle at red page 240? And that's the presidential proclamation that is dated the 24th of March 2003. It created the PCLU, and it appointed Advocate Anton Rissa Ackerman SC as a special director to head up the PCLU. Is that your authority for the removal of the cases?
No, it is not.
Please remind us what your authority is.
A reading of this proclamation makes it quite clear TRC cases are not covered here. Mr. Ncuka himself testified to the effect that he decided to move or to decide to identify TRC cases as priority crimes and transfer them to PCLU. Mr. McAdam testified in his statement that I read and his evidence that when the NPA decided to regard TRC cases as priority crimes, he then moved along with that definition to the correct PCLU unit where they were to deal. Mr. Ackerman also testified similarly, so that is my authority. Insofar as the NPA is concerned, we can say it was Mr. Ncuka's decision, but obviously he had to discuss it with people. It took some time and he only implemented it in May whereas the proclamation came out, I think, in March. So in March they were not there, but he says in May he implemented with the NPA that decision to regard TRC cases as priority crimes and move them. I was told yesterday that there's another proclamation that actually covered the aspect of TRC cases within the PCLU. I've never seen it.
But the nub of the matter, Mr. Ledwaba, is whether the declaring of the TRC cases priority crimes by Advocate Nguka meant that the PCLU would now itself carry out investigations, and that this would no longer be the responsibility of the DSO.
Maybe I did not get your the question.
Okay. Am I correct in saying that your interpretation of the declaration by Advocate Nguka that the TRC cases were now priority crimes, and that they would be the responsibility of the PCLU, did that mean that the DSO was now freed up of the actual investigations of those crimes?
To start with, the DSO was not even initially dealing with TRC cases. Before they were moved, there was never one declaration or investigation initiated in terms of the NPA Act. I said they were brought along from the national office into the SNPU. So the SNPU1 in Mr. Nguka's office worked on them without a mandate. They brought them in, the DSO worked on them without a mandate, and then taken them to the PCLU, where they are now regarded.
Well, let's deal with the 14 cases that were with the SNPU stroke DSO without a mandate. Let's not quibble for the moment as to what legal authority they were, that the SNPU was seized with at that time. The fact is that they were with the SNPU stroke DSO. Did the declaration that these crimes were now priority crimes mean that the DSO no longer had to investigate those cases?
Again, I said, even though they brought them along and worked on them, they were never declared as DSO authorized investigations in terms of 28.1A by the head of operation or 28.1B by the national director. It was a carry-on that they brought along and moved with it.
Yes, let's move beyond the legal provisions, which we've dealt with ad nauseum. The fact is that they were with the DSO. If they weren't with the DSO, there'd be no need to transfer them back to the PCLU or to the NPA. I don't wish us to quibble about it, but I'm simply putting it to you that those cases were with the DSO at that time.
In the SNP unit.
In the SNP unit, yes.
Yes, but they were not DSO authorized investigations in terms of that the head of DSO or the head of operations were ever accountable on those.
Well, that may be, but as matters stand, they were being investigated by the SNPU at that time. There is evidence to that effect.
Yes, with the powers that they brought them with the national director. It was only those 3 or 4 policemen that worked on them, but not as designated DSO investigators. They were never designated under the NPA Act to work on TRC cases. They were carrying on their own powers that they brought along.
Now, does the PCLU have any powers to investigate?
That's what the proclamation says. It says quite exactly that their mandate is to investigate and, if I may read out what it says, they direct investigations and prosecution. So they're doing both. It's not only like a DPP prosecutor that is only assigned to prosecute and SABC is investigating. Here they're given both.
Well, that's simply not the case, because a plain reading, and let's just repeat it, in particular to the head, and this is at paragraph A, in particular to head the PCLU, and here's the nub, and to manage and direct the investigation and prosecution of crimes. Manage and direct, not do the investigations, it's manage and direct. It's what
Yes.
prosecutors do all the time. They don't do the investigations themselves. Surely that's plain to see.
A normal definition of a prosecution does not say they must manage the investigation. Never. You can even check in the Act, it talks about managing the prosecution. The investigation is left under SAPS Act. But this one, more like the DSO, it gives the combined. Investigation and prosecution is combined on the DSO and the PCLU. I'm not the author of this, it is here. The PCLU is given the powers to deal, manage, and direct investigation. There's no way a prosecutor in the PCLU can manage an investigation that falls outside their mandate.
Yes, please.
So are you saying that the President of the Republic of South Africa didn't know what he was doing?
I'm saying a reading of the Act is plain that they gave them both powers to investigate and prosecute. The fault was that there were no investigators. So the intention is quite clear. They are dealing both, but the implementation was somewhat different. They forgot to appoint, or they decided not to appoint investigators for them. On somebody's understanding that Mr. Nnuka said his understanding was that SABS will carry their constitutional mandate. SABS, on the other hand, says President says TRC's cases are now NPA. They believe this entailed DSO. That's what the problem is.
So what did you understand, and you're referring us to it now, what do you understand
That the
by
peace,
manage and direct?
that the PCLU has been managing and directing investigation in conjunction with SABS, with all these identified cases in this paragraph. And they worked with SABS, no DSO involvement at all. So when the TRC cases are now regarded as priority crimes, they must similarly follow that route and be dealt with SABS. That's how I interpreted it.
And that was your view then?
Well, with my boss, Mr. McCarthy, when we took that decision, even Dr. Amaide, I'm not so sure whether Mr. Bulelani Nnuka was also with us, but he knows, he was aware of the decisions we took, that we are transferring, in complying with policy, transferring them to TRC, to PCLU. It was not a one-man decision.
Thank you.
Thank you, Commissioner. Mr. Ledwaba, under the law and the Constitution, is the NPA allowed to carry out its own investigations?
NPA has branches. Right now there's an
Aside from the investigating directorates and the DSO at that time, can the NPA carry out its own investigations?
If one reads the proclamation of the PSLU, it is there, yes. I think there was a unit of soccer. I can't remember whether they had their own proclamation, but I think they were also doing investigations in conjunction with SABS.
So let me put it to you again. Well, let me just cut to the chase and put this proposition to you. Aside from the investigating directorates, and of course the DSO which existed at that time, I put it to you that under the NPA Act and under the Constitution, it is well known as a matter of law, it is trite, that the NPA has no power to investigate its own cases.
I agree. That's precisely why the DSO is created and given a special power as tracker principle to do investigations themselves within the NPA. So the Constitution gave two powers, one to SABS to investigate, one to NPA to prosecute. Then in 2000, some people decided rather let's merge a unit in the NPA that can deal with the two together so that it is streamlined, and that's how the DSO came into being. Now it's IDEC. And there was also another proclamation on PCLU. So if it was just to be accepted that prosecutors will do prosecution, police will do investigation, this proclamation was unnecessary.
And I want to put it to you further that a presidential proclamation cannot overrule a statute or the Constitution.
I agree.
So now that you've agreed those points, I'll take you back to the proclamation that managing and directing the investigation of cases does not mean actually doing the investigations, but simply managing and directing them as prosecutors do on a daily basis around the country.
That's the council's definition. I have a different definition. We will never agree on the definition. That's the beauty of the law.
Well, it's not a question of the beauty of the law. This
Mr.
isn't
Bani, where are we going to? Running in circles here. This aspect can be addressed and can be argued because all aspects of it have been put to the witness.
Yes, Commissioner, and I do intend to move on. I just wanted to put it to the witness that he was being unnecessarily evasive on this simple matter, simple question of law.
Go ahead.
Mr. Ledwaba, as I've just mentioned, I'm putting it to you that we will assert that you are being unnecessarily evasive on a simple question of law. But I'm going to move on. Now, you were aware at the time that the PCLU did not have investigative capacity.
I was aware. They actually even asked, identified 6 after the police rebuffed them, came back to the national director, asked that 6 investigators that they identified, I think Mr. Lisk, Mr. van der Merwe, I can't remember all of them, be, according to them, temporarily assigned to them. They didn't say, we believe they must just come and work in terms of this. They must be temporarily assigned. The national director, not Ledwaba, not McCarthy, the national director, in a meeting, declined their request. So it is not a simple matter that the DSO did this. No, it was dealt properly by the national director. As Mr. Advocate McAdam says in his affidavit, in his testimony, that he specifically directed a memo to the national director after the DBA letter requesting identified 6 DSO investigators be temporarily assigned to them. So there was just an anomaly situation then. The national director himself declined that request. And sorry to say, I do not believe that I'm being evasive. Whether we were correct in interpreting it as I'm sticking to that. And it cannot be evasive, but I'm saying that's how we interpreted then.
Sorry, I think I might have just missed your evidence in relation. Did you say that the national director rejected an offer of some support or some investigators? Can you just repeat that evidence, please?
I'm saying if you look at my first affidavit, if we go to it, the one of 14 April.
you're perhaps referring to page 25?
Of the red 25,
Yes.
correct. And more particularly paragraph, if the commission will allow me a sec just to refer to the relevant.
Would it be 44 and 45?
No. Where I was dealing with the contacts and communication between myself and Advocate Ackerman and Mr. McAdams, Advocate McAdams.
If I may assist with permission, I look at paragraph 88, page red 38. No,
Yes.
paragraph 88.
On page red 38, paragraph 88. I'm saying Mr. McAdam, in his statement, I can't remember even if he confirms it in his testimony, averse to his memo that he directed to Mr. Nuka and NPA senior management, where he asked that 6 investigators, he even identified them, be, the word he used himself, be seconded to the unit. He also believed that those are not supposed to work with them, but they can at least be seconded to them to assist in driving the TRC cases. That's what I'm saying in paragraph 88. I'm aware that the PCLU applied to the NDPP and NPA CNM senior management that 6 DSO investigators be seconded to their unit. These 6 were all the people that Mr. McAdam worked with in the SNPU, and he identified them. And I'm saying I'm also aware that this request was not acceded to by Mr. Nuka himself with the 2 bosses of the 2 units, Dr. Ramaite for PCLU and Advocate McCarthy for DSO, not Ledwaba, but the 2. So if one were to say, oh well, DSO investigators were, as a must, supposed to do TRC cases, firstly, you cannot apply that they be seconded. Secondly, the NDPP and his team would not have refused.
So we have a situation where these cases are handed back to handed to the PCLU. A request is made for the secondment of 6 investigators. That request is denied. So as matters stood, the PCLU at that time did not have investigators for those cases. Now, in paragraph 45 of your statement, you mentioned that this was discussed in the NPA EXCO management meetings where Dr. Ramaite was in attendance, that investigations of PCLU cases would be conducted by SAPS in accordance with their mandate. Now, we haven't been able to find any evidence of that meeting or those meetings where that was discussed. Did you make any attempt to find such records?
No, I did not.
Have you Did you ask the evidence leaders whether they could perhaps make inquiries?
No, I did not. If I may quickly touch back the topic of Mr. McAdam in page 188 of his statement, read 188, where he himself deal with this request that he made, that in paragraph 30.3 of his statement, page red 188 and black 1402, he says there, Mr. Ncuka directed that I continue working on TRC cases I had handled at the DSO. Not that they were authorized, firstly he just handled them, but now he's at the PCLU. They say he must continue. Then he submitted a request that 6 DSO investigators be seconded to PSLU, and his request was not approved. It's not only what I'm saying, but he says in his affidavit. But Mr. Ncuka made it clear that the investigations should be conducted by DSO members. Mr. Ncuka, when he testified, did not at that time agree to this. He says he held a belief that the constitutional mandate of investigations was with SABC. Later he heard of the interaction between DSO, SABC, and PSLU in 2003, and only in 2004, 24th Feb and 26th Feb, he decided to use 21B to authorize those that they can be investigated by DSO. So all along, we were working on even Mr. McAdam himself, he says, may you please just second to me the DSO investigators to assist me. Not that they must, it's their mandate. He says, second them to us to assist us. So it was his view as well.
All right, my learned colleagues are busy checking the evidence of Advocate Nguka in that regard. We might come back to you. But let's turn to the directives issued by NDPP in Nguka in terms of section 281B, and we deal with this paginated page 7 from paragraph 23. We make reference to both declarations dated 8 December 2003, dealing with those 4 matters. The PEPCO 3 matter, Brian and Galunga, Motherwell 4, and the Chikani matter, and then the further directive on 24 February 2004 in relation to the St. James and Heidelberg Tavern matters. So we want to put it to you that in all these matters, it doesn't seem as if any progress was achieved. And as mentioned previously, of those 6 cases, we're only aware of the Chikani matter proceeding, and that's largely because that matter had been previously investigated. In fact, they were already able to, well, they wished to go ahead in 2004, before that matter was halted following the intervention of the Minister of Justice. But we do know that a plea and sentence agreement was struck in 2007. The PEPCO 3 matter is a sorry saga because even though there was an indictment issued in 2004, that never proceeded, and an inquest is only scheduled to take place in October of this year, and all suspects bar 1 have died. In relation to the Brian and Gulunga matter, we know from a presentation given by the DPCI to the Justice Portfolio Committee in May of 2025 that this matter was only opened by the DPCI in May of 2021. And in relation to Motherwell, that case was actually resolved in the mid-1990s, although we do think that it was referred because of the role of former Police General Nick van Rensburg, who ordered the killings. But we can find no evidence that that matter proceeded or indeed was investigated. And lastly, in relation to the Heidelberg Tavern and St. James Church massacres, we don't see any progress on those cases either. We refer to the McAdam email in December of 2008 to Dr. Ramaiti, reporting that SABC are still yet to conduct a series of investigations. So would you accept that in all cases there is little or no evidence that these matters were investigated at that time?
From my understanding, after these four were 28(1)B authorized and given to Mr. Ackerman, I never had anything to do, except what I'm now catching up with the developments of what happened after I left the NPA. And it is a sad story of affairs that I have to concede. But just on, as Council was reading in paragraph 23, I'm being misquoted to say that in paragraph 78 and 81, I would have said Mr. Nnuka authorized 28(1)B on 8 December. I've never said that. My paragraph 78 and to 81 says he authorized the 4 on the 24th of Feb and the other 2 on the 26th. So that statement to impute 203 was definitely not coming from myself.
So if we can turn to the question of you getting reports, progress reports on investigations, given that these were DSO investigations, given that you were the head of operations and the investigating director of the DSO, why were you not getting reports on these matters?
I can answer it to say Mr. Ackerman was my level. We were both at investigative or special director level. I was the investigating director, but special director in the DSO equivalent to a DPP. I was reporting to McCarthy. He was at that level. There would have been definitely no way at that level he'll report to me, but we know he was reporting to Dr. Ramaite. So even on the projects that he ran within the PCLU, he was bound to report to Dr. Ramaite. Just on the procedure, but even on personalities, I'll put 50 cents on the table that he would never have agreed to report to me.
No, but it's not a question of Advocate Ackerman reporting to you. It's a question of your own DSO investigators keeping you apprised as to what was happening with those cases.
Unfortunately, the policy as it was, once it is given to PSLU, they carry on and report. The reporting lines were structured. You can blame us to say you should have actually tried to do that, and unfortunately it was not done. We believed it's now the PCLU's baby and they're working. They've asked us to second investigators, NPA refused. They will deal with that with SABS. How would I then ask for report from SABS within the DSO? It is easy said now, but the practicalities were different then. You are expecting me to ask SABS to come and report to me if that investigation is dealt by SABS.
Yes, I think we're at cross purposes here. We're talking about the 6 cases under which Advocate Nguka issued directives for the DSO to take up on those cases. So these would not have been SAPS investigators, but DSO investigators.
I think if we read his declaration, it simply says, I'm authorizing this. I've decided to refer.
Yes, you must say where you read from. Mr.
It's that the first of his memo of dated 24 Feb
Page?
62, red 62, and black 1745 in this bundle. In this one, he was specific to say, I've decided in terms of 28(1)(b) of the Act that the following 3 cases arising from the TRC be investigated by the DSO. In this one, he was specific to say it must be investigated by the DSO. So we authorized the investigation, designated investigators, and gave it to the PCLU to continue with it. The second one is on the following page, 63, red 63, 26 Feb 2004, where he also says refer the following matter to the DSO for investigation in terms of 28(1)(b). And he lists what is supposed to be the specified offense in regard to be investigated. Again, investigators are designated in terms of the shall in 21(b) and passed over to PCLU to continue.
So it's abundantly clear that we are talking about DSO investigators, not SAPS investigators.
If the wording of his declaration, correct. And we did designate investigators once we have declared their authorization in terms of 21(b), but they were reporting on these 6 projects to Mr. McAdam and Ackerman. I don't know how they then worked, whether they all reported to Mr. Ackerman or jointly to both Ackerman and McAdam. I really did not even get closer to the 2 then.
Yes, but these were now DSO matters with DSO investigators. Were you not obliged to keep abreast as to what was happening and whether progress was being made or not?
At that stage, I held a different view that Mr. Ackerman is my rank, level equivalent to my rank. He's reporting to Mr. Dr. Ramaite. I have nothing to say to them in terms of that department. I remain in the DSO. And SNPU reported to me with DSO authorized investigations under 28(1)(a). Only those were remaining within the DSO.
You state in your lane. You state in your lane.
Yes. There was a turf with SAPS. I didn't want to create another turf with PCLU.
But it's not a question of you getting out of your lane, and let me put it to you, that given that these were DSO cases being investigated by DSO personnel, and notwithstanding the fact that the prosecutors in the PCLU were pursuing these cases, you were obliged to follow up and get a sense of what was happening. And it's not open to you to say, well, I left that in the hands of 2 other prosecutors.
If I'm shown a statutory imperative that makes it that I'm obliged, I'll agree. But for now, there's nothing.
But these were referrals by the NDPP to you, Mr. Lidwaba.
Correct.
Yes.
Simply to
So why didn't you make a follow-up on what progress has been made on them?
My take was once I've complied with the shall of the if they were to remain investigated and prosecuted within the DSO, I would agree. It would have been, I would have been obliged. But now they are out of, they are under somebody's umbrella. I might have defaulted in my understanding that once they are not being led prosecution by DSO people but by PSLU, it's their baby. That's how I regarded it. Mr. Ackerman again was at my level. For me to go and supervise him, it is just practically and legally impossible then.
Do you accept that these remain DSO investigators?
I accept.
Well, I must put it to you.
Can I interrupt? I'm very, very sorry, Chair. Was the question investigations or investigators?
Investigators.
Thank you.
Mr. Ledwaba, I must put it to you that you're again being unnecessarily evasive on this point. It's not a question of you supervising Advocate Ackerman. It's a question of you being apprised as to what is happening with DSO investigations pursued by DSO investigators.
For me, it's the same thing. For me to do that, I need to follow up with Mr. Ackerman. There is no way I can pass him, go into his unit and ask for reports. But one accepted that at this level, he would make sure the investigations continue. Now it's 20 or 15 years later, nothing happened, and the buck is now being thrown at some people, not him or his unit.
Because as matters stand, if one looks at these 6 cases, except for the Chikani matter, as we speak here today, they remain unresolved more than 20 years later.
I left the NPA in 2006, and we're talking about 20 years later, 4, 5, 6 other people got involved. I was, as I said, maximum of March 2003 when I became head of operations until I left, but in the following year. But we know in between TRC were then given to PCLU.
Yes.
But the fact that they remained outstanding for so many years, it is a sad story of affairs.
Yes. But I do want to put it to you that even while you were there, between the end of 2003 and 2006 when you left, there was still an onus and obligation on you to follow up and see what was happening in those cases. And on your own version, you did not.
I agree. Whether if I had followed up anything would have happened, we are again speculating.
No further questions, Chairperson.
Thank you, Mr. Vani.
Sorry, could I ask a question? Mr. Ledwaba, just so I understand your evidence correctly, is it your evidence that the DSO had no business dealing with the TRC cases?
In terms of how we defined the definition of specified offense and put it in secular one, yes. And I'm saying to support that, even the national director himself took a decision of taking them out where they are not supposed to be in the DSO and put them in where he believes they ought to be.
So that was your view between 2003 and 2006?
And 2004.
And 2004.
Yes.
Thank you.
Thank you.
Chairperson, my colleagues have just brought to my attention one aspect that I neglected to raise with Mr. Ledwaba. With your leave, may I do so?
Yes, you may proceed, Mr. Vani.
Mr. Ledwaba, you made reference to the Khampepe Commission report. And I'm just just want to find the paragraph where you mentioned that.
It's in paragraph 11 as well as paragraph
Of the supplementary affidavit.
Correct.
Yes, yeah.
11 as well as, I think it's on two instances, 11 and there's another.
All right. Well, let's jump to
5
20.
and 11, sorry, 5 and 11, I think.
So you mentioned at paragraph 20 that the Khampepe report mentions in paragraph 11.19 that the Foundation for Human Rights expressed the view that the provisions of the Act which dealt with the mandate of the DSO provided very little direction to the organization. And you agree with that express view. And you pointed out that I was representing the FHR at that time. And I will accept that I made those submissions. But I want to draw your attention to a finding that Judge Khampepe made in her report of February 2006. And we did put copies on your table as well as that of the commissioners, and we apologize that we didn't have copies for the parties, but I will read it into the record. And it reads as follows. I accept that the legislature intentionally drafted the legal mandate of the DSO to be wide. In my view, this was prudent, having regard to the rationale behind the establishment of the DSO and the findings made in relation to this term of reference. For instance, it is unarguable that organized crime syndicates are not only pervasive but are highly sophisticated and advanced and command huge financial resources. They are therefore able to mount heavyweight legal defenses with a view to resisting prosecutions and/or convictions. An overly prescriptive legal mandate would render itself open to constant jurisdictional attacks and frustrate the objective for which the DSO was established. Now, after having read that finding of Justice Khampepe in that report, I must say I'm persuaded by the conclusion that an overly prescriptive legal mandate would render itself open to constant attack and frustrate the objects for which the DSO was established. Do you have any comment? Would you agree?
I agree. But I'm again saying theft of Pick and Pay with a syndicate of 5 people for 50 rand worth of merchandise will be done by DSO. I don't think that's how we have to interpret it.
Yes, well, it clearly wouldn't meet the mandate of the DSO.
It does if one reads.
Not even on the amount, the threshold amount.
That's why the thresholds are there, Mr. Van, so that there is a break between subs and DSO. But
Yes.
if one were to take the mandate as is, without breaking secular one into the picture with thresholds, 4 criteria, everything goes. As long as it meets sub B, syndicate, 2 or 5 people, organized, continuing, anything goes.
Thank you, Chairperson.
Thank you, Mr. Vani. Mr. Nalani, any re-examination? Thank you.
No resignation, Chair.
Thank you. Mr. Lidwaba, we thank you for having agreed to come to give evidence before this commission. Your evidence has become concluded and you are now excused as a witness.
As the commissioner places.
Mr. Siminya.
Of the hearings for today, we stand with your permission to continue with former Minister Maduna tomorrow.
These proceedings stand adjourned until tomorrow at 10 o'clock.